Hey folks, James Abrenio coming to you from Abrenio Law, your Northern Virginia personal injury and criminal defense law firm. In this video, I'm going to address a question that I get a lot, and actually a lot more lately. James, I think that there may be a warrant out for my arrest. What should I do? So whenever I get this call, there's a couple rules that I apply in every of these situations. Number one, stay calm. I get it. You're anxious, you're overwhelmed, you're going to lose your job, or you're going to have to go to jail. There's so many things that are going through your head. Is there actually a warrant out for my arrest? What are the charges? So number one rule is stay calm, take a deep breath. We'll figure it out. Number two, even if you're watching this video, call an attorney. Most criminal defense attorneys will do something called a free consultation where you're not paying to talk to them. And it never hurts to be advised of what your rights are, especially if you're concerned about criminal liability. Whenever there's criminal liability or potential criminal liability involved, there is no reason not to get educated about your rights. Here in Northern Virginia, again, most attorneys will do free consultations. What's the next rule? Well, your next question is probably, well, James, is there a way to get this criminal charge quashed or terminated or the warrant dismissed before court before having to turn yourselves in? And the answer is, unfortunately, at least that I'm aware of, there's no way pre-court to have a warrant for your arrest dismissed, terminated, quashed, whatever you want to call it. Indeed, if a warrant is out for your arrest, the court, a judge, isn't going to even be aware of that warrant. Indeed, usually a magistrate will have issued it, and for it to even get to the court, it's got to be served upon you, and it's got to be assigned a case number with the clerk's office, and then be assigned a date by the clerk, and then that's when you're going to be in front of a judge, whether it's in custody or out of custody for an arraignment. So unfortunately, you're not going to be able to do some pre-trial, pre-arrest, pre-summons warrant serving mechanism to avoid having to deal with it. So that being said, the next step is you should confirm whether or not you have an actual warrant against you. I can't tell you how many people call me and say, hey, James, I got into a fight with a significant other or a friend, or somebody's alleging that I stole something from them, whether it's somebody they don't know or an employer. And so they have an indication or belief or speculating that there may be a warrant. And so the number one rule after that is actually figure out how to confirm the warrant exists. So in counties like Fairfax, there's actually a number you can call. They call it the warrant desk, where you can actually call in, provide your information, and they'll let you know whether or not there's actually a warrant out for your arrest. Other jurisdictions, they won't release that information, and you essentially have to go to the local police department and turn yourself in or check that way. This kind of gets back to my first point in talking to an attorney and being advised of your rights. If you can, you're going to want to have the attorney involved early on. So if you think that you might have a warrant for your arrest, you'll want to have an attorney be the one to reach out. While they may not give the attorney the exact details of what the charges are, I've been fortunate in most of these instances, I can actually have them confirm that a warrant does exist or doesn't exist. So earlier on, the better. So that's that. You want to make sure that the warrant is actually out for your arrest. Sometimes they're not. A lot of times, by the time people are calling me, there probably is, because your belief isn't just baseless. Maybe somebody said, hey, we're going to get a warrant for you, or maybe you've gotten a call from a law enforcement officer saying, hey, I need to talk to you. Maybe your employer has reported you, whatever the case may be, but just make sure that you actually have a warrant against you. Now, the next step is going to be making arrangements to turn yourself in. Again, in an ideal world, you'll want to have an attorney involved here, because there are ways to an attorney can help facilitate this. But look, if you don't have the funds, you don't have the funds. It is what it is. So you're going to have to be in a position where essentially there's coordination with law enforcement to turn yourself in. I would also recommend, if you're doing this or your attorney's doing this for you, that a bondsman is called, because if you go turn yourself in, a magistrate may or may not give you a bond. But even if they give you a bond, it may be to the point to where you don't have several thousands of dollars in your pocket. So a bondsman will make you pay 8 to 10% usually, and then they'll sign over the bond and then allow you out. Now, a couple caveats with that: if you do have a bondsman, the money that you initially put up, let's say it's a $2,000 bond and you pay them $200, you're not getting $200 back. The other thing is, if you don't show up to court, you owe that 2,000. So a lot of times, if you have somebody, let's say a friend or a parent or somebody go with you, the bondsman will make your friend or family member sign for collateral for that a bond amount. And if you don't show up, then that person is going to either have to pay that amount, or whatever collateral they put up is going to be potentially forfeited. So if you're going to have somebody help you out, you better be willing to come to court. Now, a question you may have is, well, James, what's the likelihood of me actually going to turn myself in and then not getting out? And I will tell you, it really depends on the facts of your case. The court and the magistrate who is considering your bond for the first time is making the same assessment that the court will be making. And essentially, really, it relates to a couple of things. Number one is your record, whether or not you have any prior charges and other instances in your criminal background history that leads you to be a higher risk. Number two, the underlying charge itself. If it's something like, a petty theft or something like that, to where there's not a whole lot of money, more likely than not, you should get either a recognizance bond, meaning you don't have to pay anything to sign to come back, or some type of low bond. But, situations where there's alleged violence and there's alleged serious injury, or there's a situation where you're charged with individual charges that have what we call presumption against bond. And that's in the code, in the Virginia code, there are certain charges that presume that you should not be let out unless you can rebut that presumption. And we'll in the show notes here, we'll put that specific statute for the charges with presumption against bond, with things like robbery, attempted rape, murder, these assault on law enforcement officers. Those kinds of very serious charges are the ones that are more likely to have a presumption against bond. But to be clear, you can also not get a bond or get a high bond even without a presumption. But again, the quote, less serious the charge, the better for you. Whether or not you have ties to the community, indicating that you wouldn't be a flight risk. So let's say you've got a job you've been working at for 10 years right down the street, you own a home, your cousins and brothers and mother live with you, which would indicate that you have every reason to stay in the area, as opposed to, you came in from Florida and you're alleged to have committed a crime when you are here on vacation, or whatever the case may be. Those, whether or not you're a flight risk, really. And have you ever missed court before? If you've missed court, obviously that's not going to bode well for you. But these are all factors that kind of are considered by a magistrate in totality to determine whether or not you're going to get bond, and if so, how much. So long story short, there's no guarantee that you're going to get bond. But at the end of the day, if you have a clean criminal record, the charge against you is a misdemeanor, there's no alleged serious injury and things like that, we're getting closer to more likelihood of getting a bond versus being held. Now, again, there's no guarantee one way or the other. And so that, again, bodes to why you should have an attorney involved versus doing this on your own, if at all possible. Now, the other thing is, you need to be prepared when you're going to turn yourself in to assert your right to remain silent. Remember that whenever you encounter law enforcement, which you will be when you turn yourself in to a magistrate, because a law enforcement officer has to actually serve that warrant on you, or warrants on you. Anything you say can be used against you. So you want to be very careful not to be making any statements about the allegations against you, because what you may think is an innocuous statement or non-hurtful statement may be indeed a hurtful statement. Let's say, you're charged with theft, and they ask you whether or not you were in the area, and you were in the area, but you didn't commit a crime. Well, you admitting that you were there can be used against you. So you want to be careful and be ready to assert your Fifth Amendment right to not say anything, and you don't have to be a jerk about it. Just say, look, I have nothing to say. I'm asserting my Fifth Amendment right, and also I'm asserting my Sixth Amendment right that I want an attorney involved before I'm questioned. You want to be very clear about that. Unfortunately, there's case law in cases where the court has determined, because somebody's not absolutely clear about wanting to assert Fifth Amendment or Sixth Amendment rights, that they essentially didn't, and therefore that doesn't help in keeping statements that are ultimately made out. Also, you don't want to volunteer information, because even if you assert your Fifth Amendment right and you ask for counsel, but then all of a sudden you just start talking without being questioned, that can be used against you as well. So make sure that you're ready and prepared to assert your Fifth Amendment right, because you don't want things to be used against you. Now, this is kind of a layout of things that you should be thinking about when you're preparing to turn yourself in if there's a warrant against you. Some of you may be thinking, well, James, it's the weekend, or I'm going on vacation, or I'm leaving town for a little bit. I don't really want to deal with this. I'll just deal with it when I get back. And my rule, and they asked me, James, is it going to hurt me if I wait a week or a month or a year or whatever to turn myself in? And my rule of thumb is the sooner the better. Okay, the longer you go without turning yourself in, the more likely a magistrate's going to be thinking that you are trying to evade service. And you never know when you're going to encounter law enforcement. There's a lot of reasons that you can encounter law enforcement where you would never expect it. Let's say you're driving down the road, you make a unlawful lane change, and then all of a sudden they're running your record, and boom, you've got an outstanding warrant. Well, you thought you were just going to work, now you're going to the jail, and now you're presenting yourself to a magistrate involuntarily. And again, just another factor that can be used against you when trying to consider a bond. So my rule of thumb is as soon as you can get it done, get it done. Again, you want to talk to an attorney before you do anything, but that shouldn't be a long period of time. It's usually pretty easy to get an attorney on the phone. There's a bunch of attorneys locally that likely you'll leave a message and they'll try to get back to you that day or soon thereafter to be advised your rights. But again, you'll want to turn yourself in as soon as possible with the guidance of an attorney. In a perfect world, with the actual retention of an attorney. I will say many instances people will call me, ask me about warrants, I'll confirm it, and then they'll say, well, what next? And I say, well, retain me. I'll actually go with them to turn themselves in. I'll actually, in many instances, be able to actually present an argument to the magistrate. And some care, some don't. But for the cases where it's a close call, my presence and my argument may provide that information that would gotten somebody either a personal recognizance bond or a low bond or a bond that's affordable for them, and they were able to get out. Whereas I am sure that if I hadn't gone, that they may have been spending the day in jail or a night in jail while they're waiting an arraignment and a bond motion. So these are all things that we're all working with risk, and your goal is to minimize the risk as much as you can. Of course, there's no guarantee, even if you hire an attorney, that you're going to get a bond, especially if you have a serious charge against you. So, look, hopefully this information was useful. Again, I hope one of the big takeaways is you need to call an attorney to be advised before you're speaking to law enforcement, and you need to be ready to assert your Fifth Amendment right not to incriminate yourself if and when you speak to law enforcement, to turn yourself in. But if you have any more questions, make sure to reach out to us. Phone number 703-570-4180. You can also check out my criminal defense practice page at the webpage. It's www.abreniolaw.com. Hopefully you found this video useful. If you're watching it on YouTube, make sure to subscribe to the YouTube channel. We're constantly shooting video, and people are asking questions, which causes us to shoot more videos. And make sure to comment below, like it. If you have other questions, make sure to reach out. Wish you the best. Thanks.